Buongiorno a tutti e benvenuti a questa terza giornata del festival, giornata dedicata a temi che esulano dalla materia tipica di quest'anno, cioè la vittima di reato, perché questa domenica è dedicata alle prospettive di riforma del sistema penale, processuale penale italiano, che saranno oggetto di una ricca tavola rotonda finale con grandi esponenti, grandi giuristi italiani, però preceduto da tre momenti che ci aiutano a mettere a fuoco anche le nostre problematiche, tre momenti dedicati alle esperienze straniere. Avremo una prospettiva europea come terzo momento, la prospettiva spagnola tratta da un interessante volume appena apparso e per l'appunto questa prima sessione dedicata al sistema americano. Al sistema americano, partendo da un libro molto importante di Brandon Garrett, su un tema specifico ma che consente di fare una riflessione fondamentale sulle trame future del fenomeno processuale, perché parla soprattutto di prova scientifica. Now, switching in English for the present panel, here we have two eminent speakers that I would like to introduce you. On one hand, Giuseppe Gennari, who is a judge at the Court of Milan, and I must say an unlighted judge who wrote, for example, a book on scientific evidence and defense rights, and applies every day in court the principle of due process and fair trial. On the other hand, Brandon Garrett, professor at the Duke University School of Law. There is no doubt that Brandon is among the most prominent experts of criminal justice in the United States. He is here today to answer to the questions that Giuseppe will make about his latest book, Autopsy of a Crime Lab, Exposing the Flaws in Forensics, that has just been published in March. Starting from the book, Brandon and Giuseppe are going to develop some reflections about the future perspectives of the American criminal justice system. Without taking further time, I will let the stage to the two friends of mine, thanking both of them for having accepted to take part into the festival and hoping to see them soon here in Italy, maybe for the next edition of the festival. So I leave you the floor.
Thank you, Luca. So good morning, Brandon, and welcome. Morning. As Luca just told, you wrote a really wonderful book, I find, Autopsy of a Crime Lab. I find that, in my opinion, it is a very important book that should be included in professional training program of judges and in all legal schools and courses. That's my idea. Nonetheless, I'm wondering why after DNA wars, after NAS report, after PICAS report, after many years speaking about those issues, we still need to explain the potential fallacy of scientific evidence, the hidden risks of misleading use of science in court. Judges and public prosecutor really does not understand, or you think that they prefer not to understand?
Yeah, so we have known for years now, and leading scientists around the world have been commenting on the problem, that many types of forensic evidence that we commonly rely upon don't have a strong scientific background. We also know that there are some types of scientific evidence which can be quite accurate, but they can also be misused. And third, we know that good evidence where there is strong scientific analysis that can be done can be contaminated or damaged at the crime scene if law enforcement aren't competent. Fourth, we know that even if it's a good scientific method, labs can have terrible quality control and they can make errors, and those quality controls may be lacking. We know that whether evidence has scientific underpinnings or not, you can have experts that overstate things in the courtroom and say misleading things about their conclusions. Even if they've reached sound conclusions, they can present them in a way which is misleading and not sound. There's so many different ways that forensic evidence can go wrong, and so little has been done to respond to any of those types of error. I think, like you say, there's maybe more awareness in scientific circles. Some judges are starting to talk about some of these unreliability dangers in their opinions. More judges in different countries have adopted standards, something like the Daubert standard in the US, or with different names, with slightly different factors. Their judges are focusing on reliability a little bit more when they look at experts in criminal cases. But for the most part, very little has changed, and that's why I thought it was time to write another book.
Okay. Now, I'd like to ask you something about Daubert and Daubert test, because Daubert is still a reference point in Italy. It is routinely quoted by doctrine and sometimes by jurisprudence. Could you make a comment on Daubert and its real efficacy within the United States legal system?
Yes. So, the Daubert case was decided in 1993. There was much more of an awareness that sophisticated scientific evidence issues were important in civil cases at the time. The case itself involved, public health challenges to a drug, Benedictine, which later there was, it became quite clear actually that the drug was safe, and that the litigation challenging the use of this drug was based on faulty data. And so there was this concern that plaintiffs' lawyers trying to make money in civil cases in the US, and there's very active litigation in the tort system in the United States, multi-million-dollar cases, that they were relying on problematic experts. A lot of especially sort of conservative scholars were worried that these lawsuits were challenging companies that weren't doing anything wrong. A lot of sort of corporate interests were very upset about the degree to which plaintiffs were relying on experts that they didn't trust. That said, in plenty of other areas, there's been evidence that it was the corporate experts that were misstating the facts. Regardless, these were cases that involved tens, hundreds of millions of dollars, where both sides had experts, where there were big battles of the experts, and where judges could see that here we have experts that are disagreeing with each other. We know that the science is in dispute. We know that the facts are in dispute. The methods are in dispute. Everything is in dispute. And so that made it very clear to judges that when you have a dispute that is that pointed and that urgent, we need a framework. We need some way to resolve these problems. And so the Daubert decision, made sense because judges themselves wanted guidance. And the old test that they were relying on from the case of Fry versus United States just said that if it's a novel scientific technique or method, you should look at whether there's general acceptance in the relevant scientific discipline. But that didn't really help if it wasn't new science, and it didn't help to define what is the relevant discipline. And if people within the scientific community were disagreeing, well, how do you decide which side is right? And so the Daubert case set out a number of factors that judges should look at, and basically focused on some questions of reliability, although they said that acceptance within the scientific community is relevant. So is peer review and publications, but also efforts to actually test the method and find out how accurate it is by looking at whether you can falsify the theory or collect data to investigate how well the expert method works. But like lots of things that a high court does in a country, they didn't give detailed instructions to the lower court judges. They said that lower court judges should consider these factors in their discretion and conduct a hearing if they think it's useful. They should look at these factors and weigh them as they think is useful. And the federal rule 702, a rule of evidence, also set out these factors in a slightly different way, but basically focusing a trial judge on asking whether an expert's method is reliable and whether the way the method was applied to the facts was reliable, which is a good focus. It's basically a reliability inquiry. But that said, in most places, evidence-type rulings are often within the discretion of the trial judge, and any review of what the trial judge does is highly deferential. And in the US, it's an abuse of discretion standard. If the trial judge doesn't look at the factors, if the trial judge decides that it's not worthwhile to have a hearing, often an appellate court will say, well, the trial judge was reasonable, the trial judge wasn't abusive, and so it's fine. What we started to see as well, though, was that in criminal cases, you normally didn't have, you don't have tens of millions of dollars at stake, unless it's like a white collar case, maybe. You're not going to have experts on both sides. There isn't a clear right to have the government pay for a forensic expert in a criminal case in the United States. And that's true in many countries. Judges figure if there's someone from the crime lab, they work for the public, we trust them. We don't need some other expert. We're not going to pay for some other expert to look at the same evidence. And so if they're not hearing about forensics from two different sides, then they don't really have any reason to ask questions particularly carefully. And many judges are former prosecutors. They probably used fingerprint evidence. They probably used tool mark evidence, ballistics, whatever it was when they were a prosecuting attorney. And even if they hadn't themselves done it, they know that that evidence has been admitted into courts for decades, if not 100 years or more. And so what courts have tended to say is, rather than actually look carefully at the reliability rules, they've tended to say, we've been using fingerprints for 100 years. We've been using firearms for 100 years. It has been tested through the experience of being used in our courtrooms, and that's enough. And we've seen courts do that across the United States and countries around the world. It almost doesn't matter whether they adopt a Daubert type rule or what the words are in that rule. In practice, courts have tended to let forensic evidence in because they're accustomed to allowing these experts to testify in basically the same way for decades.
Yeah, I totally agree with you.
Yeah, and I think DNA testing was very new. In 1993, when Daubert was decided, I don't think people were thinking at the time that the Daubert ruling could have a big impact on criminal cases. Within a few years, commentators were starting to say, oh, this could be a really big deal. Now we have DNA testing. We have a model for using something which has statistical validation. We know about the populations and the statistical frequency of different DNA combinations. Like billions of dollars were invested in studying the human genome, and leading geneticists and mathematicians and statisticians did hugely influential work that was funded. There's a international investment in getting genetics right. They weren't spending billions of dollars to get genetics right for criminal cases. Everyone understood that there were going to be enormous implications for personalized medicine, for drugs, for vaccine development, for everything. And so all of a sudden there was this model of a science that could be used in criminal cases where they didn't just say, oh, it's a DNA match. No, they provided very precise statistics. And that caused people to question, well, wait a minute, why don't we have statistics for things like fingerprints? Why don't we have any idea how many people might also leave a fingerprint that looks similar or that might have similar hairs? Why don't we have any idea how many firearms might leave similar scratch marks on a bullet or a cartridge? We don't have any statistics. Why haven't those studies been done? We have them for DNA. And those questions started to be asked after Daubert. And so many thought that, well, maybe with this new Daubert framework, courts will start to ask, where are the statistics? Where's the research for these other disciplines? But it took a long time for courts to even begin to ask those questions, mostly because of this judicial attitude, and lawyers too, that, this stuff is fine. It's always been fine. There's no reason to get aggressive or upset about evidence that we've been relying on for a long, long time.
Absolutely, I agree with you. By the way, you spoke about fingerprint, and then fingerprint in Italy still has the stigma of infallibility. Our Supreme Court affirms that a conviction can be based only on fingerprint evidence without the need for other pieces of evidence for confirmation. Please, could you make a comment? Because I think that
I find that terrifying. But
fingerprints in the United States, and it's incredible. In Italy, absolutely not.
I mean, I find that statement by the Italian Supreme Court terrifying, but also the same as what you see courts in the U.S. and lots of other countries saying. I mean, the fingerprint is almost even like a symbol for individuality, or people talk about. I don't know if there are metaphors like this in Italian, but in English, there are metaphors like that artist had his fingerprints all over it, or the musician's fingerprints were all over that song. Like it's sort of a metaphor for putting your individual stamp on something. And even in the early years of DNA, people called it DNA fingerprinting because they thought maybe DNA will be as promising and as accurate as fingerprinting.
Yes.
And that's the reason why I began my book with the most highly publicized example of a fingerprint comparison gone wrong. in the Brandon Mayfield case.
Yeah.
And so because when I talk to readers and, especially people who are not lawyers about forensic evidence, it is shocking to people to hear that a fingerprint comparison can go wrong. People assume that fingerprinting is perfect because fingerprints are unique. We don't necessarily know that. For example, people thought snowflakes were unique, but they form according to the same crystalline pattern. And so actually there are different, sets of crystal patterns that can form when a snowflake is raindrop is falling and freezing. And in the same way, there are certain rough shapes that fingerprint patterns form. And even though they're extremely detailed objects, we don't know that there aren't any two that are alike. But more important, in a crime scene, one is never comparing the entire fingerprint. And there's a lot of information missing from a partial or latent fingerprint, which they have to use dust or powder to lift from a surface. If you think about a criminal, they're not purposely trying to roll their print very carefully to leave a really good print, which, I've had to do this, for the airport, early entry, you have to do fingerprinting. Some people, if you had to do it fingerprinting for an employer, they tell you to roll your print very slowly from right to left or left to right. I can't remember which. Sometimes they tell you to do it over again because you didn't leave a good enough print. I think actually lots of people have familiarity with this. If anyone listening or watching has had one of the smartphones that have a fingerprint reader, the little surface that reads a fingerprint on the old iPhones and Android devices was very small, and so it couldn't read your entire fingerprint. And that's why if your finger was off, or if the surface was a little bit wet, or just for random reasons, you would put your own finger on your own phone and it wouldn't open. And you'd have to do it sometimes several times. That's why a lot of the smartphone makers stopped using fingerprints. And so you have these partial prints, and sometimes the dusting or the surface that the print is left on leaves a lot of information missing. And that's part of what happened in Brandon Mayfield's case. There is this plastic bag left outside of the scene of the 2004 Madrid terror attack, the subway bombings that killed dozens of people, injured hundreds. It was a huge terrorist attack. There have been so many horrible terrorist attacks in the world since then that it's sort of faded from people's memory a little bit. But there was a bag in a white van. White vans are always suspicious. They found these unexploded detonators in a bag. So they knew that whoever did this bombing had handled that bag, and they found a single latent print on it. But when you see images of the print, and I include an image in my book, you can tell the rough shape of the print. There are certain areas where you can see some detail, and there are lots of areas where it's clear that the powder, the dust, the bag is crumpled, and so there's just lots of missing information. The FBI wanted to help bring this terrorist to justice. This is just a few years after, the 9/11 attacks. And so they run the print through this massive international database, and the fourth candidate print that gets generated was a hit to a man in Portland, Oregon, named Brandon Mayfield. Now, it was the fourth print. It was not the best print, according to the algorithm. But when they looked at the initial expert looked at the first three prints, he thought, no, it's not that one, it's not that one, it's not that one. Actually, when he looked at the fourth print, that was Brandon Mayfield's, he saw some differences as well as similarities. But in looking back and forth, he decided that those differences could be sort of explained away. And so it was a very subjective process where you're looking side to side at these objects. And we've all had the experience of, say, looking at dogs and their owners. And if you see them together a lot, you start to think that they look alike. Or you see a couple frequently, and maybe often couples do dress alike. You start to think, oh, well, that, men and women, they just look alike. You've seen them so often together. The same can be true when you're in the mode of comparing objects and your job is to find a match. You may tend to ignore things that don't match. And the FBI later, when they realized that there was a horrible mistake and did a report, they said, there's a circular reasoning that can take over when you're looking at these patterns. Yeah, so they talked about the circular reasoning, but there was also bias. I mean, this one case had everything. There was also bias. Brandon Mayfield was not just any lawyer in Portland, Oregon. He was a Muslim American who had represented people accused of terrorism, I think especially after 9/11. And so the FBI may have suspected him and targeted him and his family because of his religious beliefs. And that said, the other reason why this case is so shocking to people around the world is because there have been other mistakes in fingerprint cases that have come to light, quite a few. But what the fingerprint community would say was those are people who are incompetent, or maybe they were corrupt, poorly trained. If you follow the fingerprinting methods accurately, though, and in good faith, we do not make mistakes, period. There's a 0 error rate. And the International Association for Identification, this isn't just the FBI or the crime lab in any particular country, this is the leading international association. They said that fingerprinting is so accurate that there is a 0% error rate, and in fact, it is misconduct for any member of our organization to claim that there is an error rate or that there's a possibility of making an error, because if they're doing their work properly, errors are impossible. That was their position before the Brandon Mayfield case and before the National Academy of Sciences criticized their position as making no sense, because we all know this to some degree, that anything that humans do involves uncertainty and error. There's no such thing as perfection. Even if you're just using a ruler or a measurement, it's objective, it's a ruler. Like if you're measuring furniture, of course, if you're not holding the ruler straight, I'm terrible at measuring furniture. I always add a few more inches, because I know that if I measure the furniture and the chair arrives, it might not fit unless I give some extra room, because it depends what angle you're holding the ruler, that kind of thing. There's uncertainty with everything. And, scientific instruments will include measurements of uncertainty as part of what they report. Like when surveys or polls are issued, they include a measurement of uncertainty. Fingerprint examiners, no. In the Brandon Mayfield case, they said they were 100% certain. No doubt, no error rate. No. And it was a very experienced FBI analyst that did the work. They then brought in 2 other equally experienced or more experienced. I think maybe both were retired, but they had 20 plus years of experience. You couldn't say that they were incompetent. You couldn't say that they were trying to convict an innocent person. They knew it was a high profile case. They were trying to be extra careful. All 3 of them looked at the prints and concluded that it was 100% identification. They were all wrong. Not only that, but the defense, Brandon Mayfield's lawyer wasn't incompetent. He said, well, we should get our own expert to look at this. And they were able to get the funds to bring in their own expert. That expert looked at the markings that the FBI had made and said, I don't know, it looks like a match. And Brandon Mayfield, meanwhile, was saying, I've never been to Spain in my life. I'm innocent. That's not my fingerprint. He had never been there. The FBI found that his daughter had written a high school report about Spain and thought that, he's researching Spain. But the Spanish authorities later linked the prints, more than a month later, to a known Algerian member of a terror cell who really was in Spain and really was part of a group that had been planning an attack. And so the Spanish authorities said, we have no idea what you're talking about. The FBI refused to believe them, flew to Madrid, showing them the markups. Look at all the 15 points of comparison. They all line up. If you have 15 points, that means it's a match. Well, there were no statistics to suggest that. No one had done research suggesting that if you have a certain number of points, there's a match. And in fact, there are a number of differences that they had played down and ignored. So many things went wrong in this case. And you have to wonder then, well, how about regular cases? What if it's not 3 experienced FBI examiners? What if it's someone who really is poorly trained? What if it's a print that's of even worse quality than the one from that bombing scene? How about all these cases where there's just 1 print and not several? You have more information if you have several prints. How about these databases? Because these databases are designed to pull up candidates from people who have prints that look a lot alike. That's how you can have an innocent person blamed from across the world, because there really were a lot of similarities between the information that was in that print and Brandon Mayfield's print. That's what these databases do, though. They pull up images that look as much alike as they can possibly manage. And so the technology actually, contributed to this wrongful accusation. It wasn't part of the solution. It was actually part of the problem. And so there's so many things about fingerprinting that raise questions. And fingerprints really do have a lot more information than, say, what you see when you're examining firearms or hair or tool marks or some of these other disciplines. So fingerprints are probably in much better shape than some of the other forensics, bite mark comparisons. And yet there's a lot to worry about with fingerprinting.
Yeah, I agree. I think that we should also speak about cognitive bias is very important in fingerprint comparison and so on.
I'm sure it's true in Italy, just like in the United States and in most countries. Most people who are forensic examiners who come into court as experts are being called by the prosecution, and they work for crime labs that are funded, that are part of law enforcement.
It's the same.
Yeah, I mean, in the US, like forensics was born in like the basements of police stations. And often it was police officers who were taken off the streets because of misconduct, or like they weren't suitable for interacting with the public, and so they get put on desk duty to look at these images. Others, it's police or other people who had an interest in science. And today it's quite different. You have people who get forensic science degrees, who have PhDs, to work with DNA or to test drugs. Like you have to have a chemistry background, you have to know statistics. There are many more professional scientists in crime labs, and the labs themselves have become much more professional than their early roots. But still, you have people their client is law enforcement, police, prosecutors. Yeah, that's who they communicate with. They may not even have to share information with the defense or a judge necessarily. They share primarily with police and prosecutors, and they get a lot of biasing information.
Yeah, I agree. And speaking also about accreditation and certification of laboratories, what do you think? Because, for example, in Italy, very few private laboratories have accreditation. Proficiency tests are not performed. They are not requested by judges. On the other side, I think that accreditation is a very important starting point.
Yes, it's just a starting point, but it's important. So I think, I'm sure that hospitals in Italy are accredited, right? If you go for a COVID test,
absolutely,
you don't just go to someone who says, I'm good at testing it for COVID. Any hospital or a scientific laboratory, like at a university, will have site visits. They'll have auditing. If you have your blood tested, any lab that is testing blood will also have blind tests where someone else knows the answers, and they can see whether the equipment is working properly, or whether the medical professionals running the tests are making errors or not, because they know that lives are at stake. And if someone is told that their blood is negative for HIV, and they actually do have HIV, that could have risks for lots of people. And so there are serious quality controls in place, and labs will be shut down if they have quality failures.
Absolutely.
There are huge scandals, right? If they are misdiagnosing HIV, early on during COVID, when there were enzyme or other tests that people realized were not accurate and had high false positive or false negative rates. Everyone was talking about false positive and false negative rates because of COVID. And because we were comparing these different forms of testing, trying to understand which ones can give us good information given the health risks involved. Well, in basically every country, clinical laboratories are tightly regulated.
Absolutely.
Whereas crime laboratories, nothing. Accreditation is usually voluntary. There are some states in the US where accreditation is required, but accreditation of crime laboratories doesn't look like accreditation of hospitals or clinical laboratories. It's mostly, do they have procedures on paper that are sound? And often the requirements of accreditation are pretty vague. Like they'll say, you need to have a process for resolving complaints about quality or errors. They don't say, like, what does the process have to be? And they also don't really do site visits to find out whether any of the paper policies are actually being followed. They just say things like every year you should be proficiency testing people, and maybe every few years they will come look at some paper files that are hand selected by a supervisor to look at whether the paperwork looks good. So it's a minimal accreditation, and it's much better than nothing. But we've had terrible scandals in the US at labs that were accredited, and accrediting agencies say, like, well, look, we have no idea whether the work being done at this lab is of any particular level of quality. All we do is review the paper policies, and that's all we do. Another important piece of this is proficiency testing, because it's okay if you have a forensic discipline where part of the analysis is subjective. So many things that people do depend on their training and their experience. Not every test, not every method can be purely objective. And even if you're using a ruler, there's some level of interpretation, or you have to, line the ruler up correctly. Or drug testing, you have to compare the drugs to your pristine sample, but when you seize cocaine from the street, it's never going to be pure cocaine. There's some judgment to say that, yes, this has all the basic structure of cocaine. There are just a few differences because who knows what it was mixed with. there's always some room for interpretation. And that's fine. And in some disciplines, there's even more room for interpretation. And it might depend on the case. Like in fingerprinting, there could be prints that are in really, really clear prints. And so there's much less room for interpretation. Or there could be prints that are very damaged or smudged. And then there's a lot of connections the examiner has to make. They're making a lot of judgments. In some ways, it doesn't matter what the fingerprint examiner is thinking in their head. We don't care what their method is, as long as their work is accurate. And you can test them. And so you can give them sample prints and find out whether they correctly connect them or not. Now, in the past, these proficiency tests have often been very, very easy. And so they may be, some of them are really super easy closed set cases. Well, they'll be like, they're given 4 prints and 4 candidates, and each print goes to a different candidate. And so if you connect print A to print 1, then you know that the 3 left all go with each other. It's sort of process of elimination to connect everything. But some of the proficiency tests are slightly more complicated, and maybe they're 2 prints and they go to some number of 8 latent prints, and not all of them will match. And it's a little bit more like a realistic case type situation. Even still, those tests in the US, the main commercial providers, they're not there like watching people take an exam. It's not like, the kind of entrance exams for university where, everyone is timed and there's someone watching to make sure no one is cheating. People can take these proficiency tests in groups, and they can check their work with their supervisors or their colleagues. They're given unlimited time. And by and large, people say that these tests are really easy and don't actually, tell you anything about how good someone is. The exception is when there's blind proficiency testing that's done, where people don't know that they're being tested. And there are a number of European laboratories that have a consortium where they do blind proficiency testing. It is regularly done in clinical laboratories. And there's basically one laboratory in the US that does a lot of this. Some others have sort of experimenting with the idea. But in Houston, about 5% of all the cases are fake cases. And people don't know that it's a fake case. They disguise it very well. The staff gets prizes if they guess that a case is actually a blind test. And so they've turned it into a little bit of a game. And so any case that, if it's a fingerprint examiner, every month they will be getting some cases that are a test. And someone in the quality unit can assess whether they got something wrong. And if so, they might try to figure out what went wrong, talk to the person, do some remedial training. And the idea is that errors happen, but you catch them. And ideally, you catch them in cases that aren't real cases where no one will be harmed. And you can also generate information about how good each expert is. Because otherwise, you have no idea how good a particular fingerprint examiner or firearms examiner is. They say that they're good because of their experience and their judgment and their training. But if a doctor told you, I'm good because of my experience and training, you wouldn't just pick that doctor for that reason alone. You might want to find out, like, are their patients living or dying? For some doctors, you might worry that if they've been a doctor for a long, long time, maybe their eyesight and judgment isn't good anymore. Maybe a young doctor has lots of energy and has more recent education, and maybe medical education has improved. You don't want someone who learned the way things were done 50 years ago. That said, if someone is in their first year of being a doctor, maybe that's too inexperienced. I wouldn't want a surgeon who's only been a surgeon for 1 year. Right? There are all these questions about how good is this professional? And you can get data on that, and certainly you can get information because you have heard things from other patients. Since everyone knows, like, if the patients are healthy, if the patients have recovered well after their surgeries, that the surgeon must be doing well. Well, like with fingerprints, if they find a fingerprint match, the person will probably plead guilty or be convicted right away. And we have no idea whether they're making mistakes or not because no one is checking their work. And it's not like a patient that comes back and says, look, you did the surgery, but my leg still doesn't work. I still have that pain. It didn't fix the problem. In criminal cases, no one knows how good someone's work is because no one is being tested. And that's why the testing is so important. And yet very few places in the world actually test these experts so that we know whether they really are experts.
Thank you very much, Brandon. I agree with you. That's a great problem of the selection of the experts, a very great problem also in Italy. Now, I'd like to do a couple of more general questions. Do you think recent presidential elections will have any impact on the immediate future of criminal justice in your country? And are there specific reforms that are currently under discussion and that could have a strong impact on criminal cases?
So in my book, I certainly talk about a lot of serious miscarriages of justice in the United States. And I certainly hope that other countries learn from the mistakes we've made in the US. There are certainly some contributions that the US has to offer as well, including that we've invested in at least having, the National Academy of Sciences report on some of the challenges facing forensics. We had the PCAST report showing how there is a lack of statistics, a lack of validation studies done. We know very little about the error rates for many important forensic disciplines. And so, I think there in some ways, because we have a jury system, there is more anxiety among judges about scientific experts misleading jurors, and that can create some case law. And, in recent years, there have been some judges that have expressed concerns about firearms evidence, for example. And so, and there's also just, a lot of research funding compared to other countries, given wealth in the United States and given the role of the federal government. Even, during the Trump administration, the PCAST, the Presidential Council of Advisors on Science and Technology, had no members. Like, there was no science function at the White House. It was not a pro-science administration. And that said, there was still good funding for a lot of forensics research. We expect that under the new administration, there will be more funding to do basic forensic science research to try to improve some of these disciplines or bring in statistics. And, one of the lead author of the PCAST report, Dr. Eric Lander, who played a lead role in decoding the human genome. He's a geneticist and a mathematician, but has also cared about forensic evidence and spoken out about concerns with forensic evidence for decades now. So he was appointed to Biden's cabinet, and to have a scientist in a cabinet level position is really unusual in the United States, and it's exciting. We still aren't sure, what the forensic science priorities of the new administration will be. There had been, for example, a National Commission on Forensic Science that the Department of Justice at the federal level had convened, and that was disbanded when within a couple of weeks when Trump and took power and William Sessions was Attorney General. We don't know whether a commission like that will come back or whether there might be other approaches that the federal government takes. But we do suspect that given the, how Joe Biden ran for president saying we need to bring science back, that science is important, not just to fighting the pandemic, but federal policy more generally. I suspect that there will be more concern with making sure that sound science is used in criminal cases. I think it's still so far too early to know what that will look like exactly.
Thank you very much, Brandon.
It's great to see you. Stay in touch. I'm looking forward to holidays too.
Absolutely.
We all need a break.
Ciao, Brandon.
Ciao.
Ciao.